webinar on the topic home office and quarantine and other questions. Home office increasingly became a big topic in recent months and years. However, the current pandemic COVID-19 situation gave it again in another picture, home office, because it's now not only benefit for employees or office optimization tool for employers, it's now also a tool for business continuity, because we now see that the pandemic will likely last for a certain time, and there will be employees also in the future who will be in quarantine. And employers have now to consider two questions. What to do if I have key employees who can work from home, but they cannot attend work at the workplace? And why to pay compensation to employees who can work from home, who, however, they need to be in quarantine and they are not allowed to come to work. So should we pay them a compensation and they will do nothing, or they will work from home at least for 60%? It can be also useful for the employee to have them on home office. So this is why home office in this time of pandemic. Next slide, please. We will speak today about what is actually quarantine, because the word is used often and it doesn't mean the same in all situations. How to combine quarantine and home office, how to quickly set up a home office, and what are the basics that need to be considered when we are setting up a home office. Then related questions in the current pandemic situation, business trips, annual paid leave, sanctions related to quarantine, and how to use labor capacity when we have a drop of sale. A big topic which will be also amended by my colleague from a tax department are compensations paid to employees during home office. Next slide, please. If we start with the topic quarantine, we hear a lot quarantine, but there are two types of quarantine, and depending on the type, there is a different high of compensation which must be paid by the employer to the employee. There is an obligatory quarantine, which is the quarantine imposed by a physician or a public health authority to an individual. This is typically in a case when an individual returns from a high-risk country or he had a contact with an infectious person. In this case, the employee can ask so-called neschopenka in Czech. It's a certificate that authorizes him actually to stay at home. It's an excuse for the employer, and he is then, based on this certificate, he has right to receive a compensation of salary in an amount of 60% of average earnings. This is for the first 14 days of the quarantine. From the 15th day, it's paid from the sickness insurance. Then there can be a quarantine which is voluntary, so which is imposed by the employer. Employer is afraid in the current situation, and he can ask employees to stay at home or work from home. In this case, if employees don't work, they would still be also allowed to receive 100% of average earnings. Home office as a tool can be used in both these cases. In the case of a voluntary voluntary quarantine, it's actually the tool that allows the employer to leave employees at home, because they can work, they receive salary, and still the precaution measure was made and employees are not in one office. Home office can also be used in an obligatory quarantine. So also when a state health authority or a physician impose obligatory quarantine, if the employee can work from home and he wants to work from home, he can be on home office. What is to keep in mind in this case, he cannot have this neschopenka, this certificate that is issued by the physician, because when the employee has this certificate of incapacity to work, he cannot be put on home office. If I can move to the next slide, please. So what to consider when we want an employee to work from home in a quarantine? First, we need to consider type of work. Is it actually possible for the employee to work from home? Not all positions can logically work from home. And here a point is that potentially also when the employee is not able to work from home for 100%, so there are some tasks that he cannot do from home. Maybe it's still useful for the employer that he works from home, even though he's not able to do everything. The second thing is the employee sick? So he should be in a quarantine, but maybe he's feeling sick and he doesn't want to work. So this must be considered whether he's fit to work actually. And does he have all the necessary equipment? So are there laptops? Is there internet access, VPN connection to the firm's system? Then we have to make sure that there is just one solution chosen. So if an employee should work from home, he is not allowed to have this certificate for incapacity of work, so no neschopenka, and it's not possible to say, okay, there is a neschopenka, there is a certificate for incapacity to work, and this compensates 60% of the employee's salary, then he can still work for this 40% and we will pay him this part. So this is not possible. Either home office and 100% salary and work, or an incapacity to work and this certificate of incapacity. Yeah, sick note. Okay, I have just received it. It's a sick note actually. So we have to choose. And last point to consider is that it is not possible to unilaterally decide the employee will work from home office, but we will decrease his working hours. So if he has in his employment agreement 40 working hours a week, then we cannot say unilaterally as an employer it will be just 20. So it's possible to agree with the employee, but then we have to make an amendment to the employment agreement. Otherwise, working from home still means on the same terms and conditions as working from the office. Next slide, please. Occupational health and safety. One point where home office also can be used as an argument is that an employer is actually by law obliged to arrange occupational health and safety to all his employees. And in case of pandemic situation, one tool how to assure this health and safety maybe also home office. So this voluntary home office as a precaution by the employer who sends employees home so that they are not in a close contact to colleagues in one office. With occupational health and safety relates an often question which we receive from our clients, and whether employees can refuse to work because they are afraid in this situation, or because they don't have protection, so the employer does not have, because it's not possible to buy it now, the protective equipment. So the response is no. Employees, like in standard positions, they cannot refuse to come to work, and if they do that, then it's not in line with law. So they have to come to work and they have to work. And it's also an excuse for the employer that if it's not possible to buy the protective equipment, he logically cannot provide it. If we move to the next slide, please. So home office, what do we need to consider when we want to set up a home office? Next slide, please. One point maybe is what we have to consider is home office abroad, and I leave Lucka to tell us more about this.
Mm-hmm. Hello, everybody. So home office abroad. When we were preparing the presentation, we come to a situation that lots of you were in a situation that actually you have to immediately solve the problem with your employees abroad. Basically, I would say that if you consider assigning your employee abroad, you take into account many criteria. And I am sure that you plan this activity in advance, I would say quite well in advance. Because before leaving his home country, the employee or also his employer must comply with many rules. I mean, basically with immigration regulation and labor law in order to be able to work in the destination country. When they have overcome these first two obstacles, then you have to deal with several areas related to tax. I mean, to both corporate and personal, especially the taxation of the employee and also the risks of permanent establishment. And of course, then you have to tackle the social and health insurance deals. And therefore, in this case, employers usually carefully consider all their duties and possibilities to comply with all these necessities. But the situation around coronavirus puts many employers in the middle of the matter. And when many employees could not return to the Czech Republic, or some employers in that case had to decide what to do in a matter not, time in advance, but in a matter of days or even in a matter of hours. As a certain advantage was that if the employee had some necessary equipment for his work with him, I mean a laptop, telephone, data connection, etc., and the employee was willing to continue working from where he was at the moment, it could maintain and continue the activity of his employer. In many cases, even so that the client did not even notice any difference and appreciated the smooth transition or continuance of his business. Well, the borders were closed and there was no time to tackle with these mentioned risks, but luckily for this purpose, the OECD came up with its analysis, or better say guidance, of home office and the potential permanent establishment. Actually, the risks could be mitigated or diminished by giving a detailed explanation of what home office in this situation is. And actually, the OECD asks the tax authorities to consider this situation with a certain tolerance. The reason is, or their explanation is, that the pandemic has forced governments to take unprecedented measures, such as, of course, restricting travel and implementing strict quarantine requirements. Therefore, individuals who stay at home to work remotely are typically doing so as a result of government directives. Actually, I would say it's sometimes as a force majeure, not an employer's requirement or intention to ask the employee to work abroad. Therefore, considering the extraordinary nature of the COVID crisis, and to the extent that it does not become the new way of working from home, I mean intended working from home forever or for a long period, it would not create a permanent establishment for the employer, either because such activity lacks a sufficient degree of permanency or continuity. However, the threshold presence required by domestic law to register for tax purposes may be lower than those applicable under a tax treaty and may therefore trigger corporate income tax registration requirements. In addition, not all income taxes are covered by the applicable double tax treaty, especially, for example, state income taxes in the US. But the tax administrations are therefore encouraged to provide certain guidance or rules on the application of the domestic law threshold requirements and domestic filing and other guidance to minimize or as much as possible to eliminate burdensome compliance requirements for taxpayers in the context of this crisis. As a result of this, we noticed that in the middle of March, France has agreed, for example, with Belgium, Luxembourg, and Switzerland to allow the cross-border workers to work from home during the coronavirus quarantines without affecting how they are taxed. So this could be a good way how to tackle this point, and it's not necessary to tackle with the taxation. But as I said at the beginning, it's just a guideline and depends on the tax authority in each country if they come up with this solution as well. Unfortunately, for the time being, we have no information how this will be handled in the Czech Republic or in Slovakia or Poland. So please be careful and don't underestimate this situation. And we will be looking for the data and for the approaches of the certain tax authorities. Please, next slide.
Thank you. Yes, I'm here. Thank you, Luzka. So we see that although we previously repeatedly advised not to use abroad home office in the pandemic, in the current pandemic situation, which is extraordinary, it's we don't say do not use it, and it's possible to use also home office from abroad with certain potential risks. I have received a question regarding compensation of salary at home office. So this is to the first slide where I said that if an employer makes as precaution measure a quarantine of employees, he should pay to the employees 100% compensation of their salary. So this is when they don't work from home. So they stay at home as a precaution measure, but they don't work. In this case, they should receive 100% compensation. And this is why we recommend, if it's possible, to use home office, because then the employer doesn't have to pay 100% compensation, but he pays a standard salary and employees work from home. So yes, I confirm that if employees work from home, it's on the same terms and conditions as working from the office and on the same salary. And we now come to the points what to consider when setting up a home office. So first, we really need to know, to identify what employees and groups of employees can actually use home office. So it's clear that it's not possible for all positions or all types of work. Then it's important to consider that the place of work of the employee should be moved to the employee's home for labor law reasons. And for all of that, we need to have to do some paperwork and to do some documentation. We always recommend to have two types of documents to implement home office. First, a directive, an internal regulation, which sets a general framework for home offices. So in a directive, there will be typically identified groups of employees for whom home office is available. The system how home office will be applied, so whether it's now said everybody will be on home office from 2, or whether there will be some system of request for home office, or how this will work. Then working hours should be set down also, and how people should communicate with the team. So also this should be always considered. There is a big question of working hours, because we sometimes hear that under Czech law, under Czech labor laws, there is just one section in the labor code which governs home office, and this should be the section 317, which actually says that in case of working from home, employees organize their working hours themselves. So we don't agree with that, and I think it's rather a common opinion among Czech employer lawyers, the employment lawyers, that even when employees work from home, the employer can organize their working hours, and it's also recommended. So there can be semi-flexible, that the employer sets certain times which are fixed as working hours, and some time where it's flexible, but we do not recommend that the employee organizes his working hours himself. This is very important also for the because most of the employees we have working teams, so it must be fixed when they will be available to work with the rest of the team. And all of this should be then put down in the agreement with the individual employee. So the specifics, the specific working hours of the employee, then the place of work, which is very important, that there is a specific place of work where the employee will work, and this is typically the home address, but it can be also the address of a weekend house, because we see situations where employees work also from weekend house. So there can be also this address or both addresses, but in this case, the employer should always know which day the employee worked from which place. A very important other topic to be governed in the agreement with the employee and in the directive is health and safety. This is very often something employers are afraid of when setting up home offices. We don't think it's such a big problem, but there should be rules, and the employee should agree with the individual agreement that and confirm that all his equipment and the working place complies with the necessary rules and health rules for how much light there is, and so. In this case, when employees will work from home for maybe a longer time, this is even more important. There should be also some instructions how to behave when working from home, but typically most of them will be the general health and safety rules that will be included. But still, this is something which should be in the individual agreement with the employee. There should be also agreed that in case of some health work-related injury, the employer will be authorized to enter the home office, the home of the employer, and he will so that he can check the place, what he has as an obligation from labor law. The other thing, and one of the most important things which should be agreed in the individual agreement with the employee is financial compensation to the employees, which Lucka will speak about shortly. One more thing from my side is the signing of the agreement, because typically this individual agreement with the employee should be in writing and signed by both parties. But we can imagine that in this exceptional COVID-19 situation, under circumstances, the agreement with the employee can be agreed via email or PeoplePort. However, we do not recommend that it is used in such a way for future when we want to use home office as a benefit in future times, but only for this exceptional COVID situation. I sometimes hear questions whether it's necessary to have actually an agreement if we cannot just use a system where we ask the employee to stay at home and he stays at home. We don't advise this method because it's important for both parties, the employer and the employee, to have some rules, and also the employee must agree to work from home. So we need an agreement from the employee that he will work from home. And so when we still need an agreement, it's ideal to do it by an agreement which will already include also other terms and conditions, and we can just have it by email in this situation. And now to financial compensation, which Lucka will speak about.
May I ask you for? Yes, sorry. May I ask you for another slide? Okay, so I'm talking about the financial compensation, but before that, firstly, I would like to define what we mean when we are talking about the workplace or about the tools or technical equipment, as Eva mentioned, also the work safety and hygiene. Basically, we can define which tools or under certain conditions the employee can work from home. Of course, we have to take into account not only his knowledge, his ability, but also we have to think of that he needs the basic things like laptop, phone, internet or data connection. Also, he needs some applications to communicate with the team, for example, and all these things are necessary to be taken into account when you define the workplace. In practice, and based on the labor code, the employer usually provides his employee with proper tools and workplace, equipment of the workplace, or the employee can use his own equipment, and then he is entitled to a compensation based on agreed conditions. And in these matters, sometimes we have questions on if the employee can waive this compensation. Or we think it's not possible because it's his fundamental right or his claim, the employee's claim, and therefore we highly recommend to make an agreement with the employee on the definition of the workplace, his necessary tools and other conditions, and also on top of that, also to mention the employee's compensation. It's also important to mention that an employer can determine the necessary homework equipment, and the employer can define which equipment he's going to provide to his employees, and which they are entitled to use from their own resources. In practice, the most common company equipment provided to employees for work at home can be a laptop or phone, and then employees can use their own tools or equipment, such as, for example, external monitor, keyboards, desk, chair, proper chair, and proper or good lighting of the workplace. Considering these last things, of course, you can determine if this equipment could be used only for the work of your employee, or it's his own tool or his private equipment and can be shared with his private activities too. In that case, you can pay just a proportional part of the price of the tool, and it's not necessary, of course, to consider the total purchase price of these tools. Well. What can be the tax implications of home office reimbursement? It's necessary to say that it's very similar, or actually it's the same as travel reimbursement. What I mean? It means that for employer, if all the conditions are met, it could be a tax. It could be tax deducted costs. It means it's the maximum advantage from the tax act, and for the employee is tax exempted income, fully exempted income. Based on some rules. What I mean, it means that you define the rules of the homework, and you define the tools. I mean the usage for his work. Also, there were some questions on if this reimbursement can be paid as a lump sum. Yes, could be, but there's some but. Firstly, I would like to mention that the calculation of reimbursement was confirmed by the coordination committee between tax advisors chambers and the General Directorate of Finance in November last year. And it covered two things, or two measures. Firstly, that the conditions or the reimbursement for tools can be fully paid as a lump sum, but the possibility or the cost of creating and observing working conditions based on the labor code, such as cost of heating, electricity or telecommunication services or internet connection, should be proved directly. It means that in this case there is a there is a different approach to this, and this amount should be paid based on the employee's proved costs. Well, may I ask you for next slide? Well, when Eva talked about the working hours at home, I would like to mention also providing meal vouchers, because you can, of course, provide meal vouchers, or if you used to pay or provide your employees with a canteen. In case of home office, it's a little bit different situation. Basically, the most often asked question was if the employer has to provide meal contributions. Of course not, because based on the labor code, the provision of meal vouchers is fully the responsibility of the employer. I mean that the employer is not obliged to provide the contribution, but only employer is obliged to enable the employees to have meals during all shifts. And based on that, you can decide if you will provide your employees with meal contributions or not when they are working at home. Of course, if you have if you provide the canteen and your workers are at home, I think there's no sense to come back to work and have the meal there. But you can provide them with meal vouchers, and so that your employees can spend the vouchers for the lunch during their home office. But what should you do when you would like to benefit from what should you do when you want to have the benefits, the tax benefits from these vouchers? Basically, there are three main rules you have to keep. Of course, the meal voucher value. I'm sure that you know that there is a maximum tax deductible value. I mean, the meal voucher nominal value should be a maximum 131 crowns for this year, and I think this is not the problem. Also, you are obliged to, or you can provide you can use the tax deduction in case that the employee is not entitled to meal allowances on business trip. And the last condition, I mean, this is the basic thing, and it goes back to what Eva said about the working shifts or about the working hours, because the Income Tax Act asked or demand that if you want to use the tax benefit, the shift must be set ahead, and also that the employee's presence at work during such set shift at least must be at least 3 hours. Therefore, if you do not set the working hours, even semi flexible or fully flexible, but you don't keep these 3 hours every day, of course you can provide your employee with the voucher, but unfortunately this cost wouldn't be the tax deductible for you. Therefore, we recommend to set the shifts at least, the semi-flexible hours, and with respect to the 3 hours, and therefore you can provide your employees with the meal vouchers and benefits from all the tax benefits. Well, next slide, please. And this is just the explanation about the home office reimbursement, about the lump sum. So I think that it's not necessary to go deep in the detail. As I said before, you can provide the lump sum reimbursement for home office, and but be careful when calculating the cooling, electricity or heating or data connections, because it should be proved directly, not based on the lump sum. Next slide, please.
So what are the basics for a home office? When can we use home office in case of a quarantine? As a summary, home office can be used as a tool in case of an obligatory quarantine, which was imposed by a physician or state health authority to the employee. But the employee cannot have a sick note, this neschopenka, which I mentioned, and be temporarily unfit to work. It's not possible to combine that. It can be used for a voluntary quarantine when an employer decides that he wants to leave employees at home, but he doesn't want to pay 100% compensation for no work, but he agrees with employees that they will work from home. It can be also used when now we have school closed for employees who need to take care of older children, because I always say home office is not a vacation, so it's really not an option for parents of smaller children where they are not able to actually work taking care of small children. What we need to consider when we set up an home office is always whether the type of work is actually available for a home office, and we always need to have documents which I mentioned. So I have now a question here, whether instead of an agreement on a home office, it's possible to have just an acknowledgement from the employee assigned that he acknowledges all the health and safety rules which are in an internal regulation. So no, because the basic reason of an agreement on home office is that it includes the actual agreement of the employer to work from home, and the other place of work, which is important, so that it's not a business trip, the working from home, and Also, in case of the health and safety rules, it's a stronger obligation, because in a two-party agreement, the employee agrees, and he has the obligation that his home working place complies with all the health and safety rules. And in connection with the fact that the employer then pays also the employee a compensation for this compliant equipment. It's in case of any dispute on health and safety, much stronger position for the employer. So, as we advised earlier, always have an internal regulation specifically on home office, and have an individual agreement with each employee. If we move to the next slide. This was for the home office, and we also have some related topics here. We still have 20 minutes, so we wanted to present some other topics which we receive often questions on. One is a question about business trips, whether an employee can refuse a business trip. So actually an employee must agree with each business trip, but typically this agreement is given in the employment agreement pro futuro. In case you have such an agreement in the employment agreement, then the employee now cannot refuse a domestic business trip within the Czech Republic if it's not to areas which are really isolated by a decision of the health authority. Employee cannot refuse this business trip. It's similar to what I said before, that employee cannot refuse to come to work because he's afraid that he will catch the virus. A different situation is with foreign business trips. I know that now there is a prohibition to travel, but if this is waived, or if there is some exemption obtained, in case of foreign business trips, we believe that even though there was a general agreement to be sent to business trips in the employment agreement, in this specific situation, the employee can refuse a foreign business trip under the circumstances with the pandemic. We can move to the next slide. Annual paid leave, what is also considered as a tool of employers how to solve the current situation with the pandemic, whether an employer can order to employees annual paid leave. This is possible. However, the employer must always order annual paid leave at least 14 days in advance. So it must be the employee must be informed at least 14 days in advance, and it's also not possible to order now to employees the whole unpaid leave, the whole paid leave for 2020, because the meaning and the purpose of the annual paid leave provisions must be still kept in mind. So we recommend to use unused holidays from last year's, from previous years. This is an ideal tool. It can also be ordered some part of this year's holidays and this year's paid leave, but not all 4 or 5 weeks. When we want to order collective leave to the whole, to more employees, or actually to the whole business, we have to keep in mind that it would be a collective leave, and there are specific rules in the labor code, and it must be maximum of 2 weeks, and if there is trade unions, there must be an agreement with them. In case of unpaid leave, which we also see sometimes that employers try to use, unpaid leave cannot be ordered to employees, but subject to agreement, individual agreement with each employee, also unpaid leave can be used to solve the current situation. Next slide, please. Then sanctions, often questions about sanctions, about quarantine and a home office. So breaching of a quarantine, so if an employee is ordered to be in a quarantine and he doesn't comply with this, there is a risk of a fine up to 3 million crowns, Czech crowns. And if the employer orders an annual leave to the employees in breach of the rules which I mentioned before, there is a risk of a fine up to 200,000 Czech crowns. If we move to the next slide, please. One additional point, what can be also used when home office is not really the question, and we have also other employees. So how to solve when there is a drop in sale in case of employees, in case of an employer. So we can temporarily assign an employee. This is an option subject to specific rules and subject to an agreement with the employee. An employer can assign employee temporarily to another employer. If the employer is using working hours account, so this shift planning within a compensatory period, there is logically possible to plan shifts so that there are no shifts or limited number of shifts in the time when the employees cannot work. And a big topic which is now discussed in connection with the state subvention program antivirus is partial unemployment. So if there is drop in demand for goods or services the firm is providing, then and the employer cannot assign work to employees due to this reason, then it's possible to have partial unemployment subject to agreement with trade unions, or if there are no trade unions, then internal regulation, and then employees can stay at home for the whole time or just for a part of their working time, and they will be paid for this time minimum 60% of their average wages. And yes, there is the state compensation which we presented in our other webinars, and there will be a webinar, however, in Czech on this topic tomorrow. Next slide, please. The last thing, also what is to be considered in these times of quarantine and exceptional state of the Czech state, occupational health services. We also received questions on that. So during the exceptional state, we have now until the end of April, I think, entry medical examinations can be replaced by an affidavit. So you can hire employees and you don't need the entry medical examination. It can be replaced by an affidavit. However, although there is no specific legal regulation for that, after this exceptional state is over, the medical examination should still take place, because it's a precaution measure for the employer should there be then any problem with health and safety. Also, periodic medical examinations, they don't take place during this state, and health certificates for specific employment where you need health certificates can be also replaced by an affidavit. One last point, these are good times for improvement on qualification. So you can, employers can still use the time where employees cannot work to improve their qualification. And to the next slide, please. I think that, yes, we have a specific web page, Deloitte, where all the information on COVID-19, how to mitigate the risks, and what are the topics, and not only from legal or tax, but also from consulting and our other departments. So all the information are stored on this page. It's in Czech, but also in English. Not all of the articles are also in English, but most of them. And you can also hear all our webinars there. There are links. So I recommend, or we recommend, this page when you need any information. And to the next slide, please, which is just a thank you. So thank you.
Yeah, Eva, go ahead.
Yeah, thank you for your attendance. And that.
Thank you, and have a nice day, and keep fit. Bye-bye.